So welcome back, dear students. Today we will cover the 7th lecture from Unit 3rd relating to Article 32 and 226. As all of you know that Article 32 of our Constitution is a fundamental right which empowers the Supreme Court to issue directions, order and writs in the nature of habeas corpus, Mendemus, Prohibition, Quo Warranto, or Certiorary for enforcement of fundamental rights, whereas Article 226 is the constitutional right which empowers high courts to issue a direction, order, and writs for enforcement of fundamental rights and other legal rights also. So, dear students, the right covered under Article 32 is a fundamental right because it falls in the chapter 3rd, and the right given to you under Article 226 is an ordinary constitutional right, but the scope of Article 226 is wider because a writ can be issued for enforcement of fundamental rights as well as for other legal rights. So, Article 32 is one of the fundamental rights listed in the Constitution that each citizen is entitled. This Article 32 deals with the right to constitutional remedies or affirms the right to move the Supreme Court by appropriate proceedings for the enforcement of rights conferred in Part 3rd of our Constitution. Article 226 empowers the High Courts to issue to any person or authority, including the government in appropriate cases, directions, orders, or writs, including writs in the nature of same 5 writs are there in the nature of habeas corpus, Mendemus, Prohibition, Quo Warranto, Certiorary, or any of them. Article 32, dear students, is a mechanism or an instrument through which an individual whose fundamental rights have been infringed can approach the apex court to seek remedy as well as enforcement of these rights. Thus, Article 32 makes the Supreme Court both the guarantor and the defender of fundamental rights. Dr. B.R. Ambedkar, he was the chairman of drafting committee of Constitution of India. He termed Article 32 as heart and soul of Constitution of India. Article 32 of Indian Constitution gives the right to individuals to move the Supreme Court to seek justice when they feel that their right has been unduly deprived. These fundamental rights, dear students, given to you under Article 32 can be suspended during emergency by the President of India under Article 359. And these fundamental rights are justiciable. Under Article 32 of Constitution, a person can go to the Supreme Court for enforcement of these rights. Now, the related question, dear students, is whether Article 32 is available to a foreigner. A foreigner, juristic person, can file a petition under Article 226 and 32 to enforce the fundamental rights which are available to all citizens. However, same cannot be used to invoke the rights that are denied to it under Article 19. If certain rights are not available to foreigners, then they cannot file a writ under Article 32. But if fundamental rights are available to foreigners, given granted by the Constitution, then definitely a writ under Article 32 can be filed by foreigner also. So, dear students, Article 32 is the right to constitutional remedies enshrined under Part 3rd of the Constitution, and Article 32 makes Supreme Court as protector and guarantor of the fundamental rights. We will have to look into the language of Article 32 also. Please open your bare acts and see the language of Article 32. Article 32 clause 1 states that if any fundamental rights guaranteed under part 3rd of the Constitution is violated by the government, then the person has right to move the Supreme Court for the enforcement of his fundamental rights. Article 32 clause 2 gives power to the Supreme Court to issue writs or orders or directions. It states that the Supreme Court can issue 5 types of writs, that is habeas corpus, Mendemus, Prohibition, Quo Warranto, and Certiorary, for the enforcement of any fundamental rights given under part 3rd of Constitution. And Article 32 clause 3 states that Parliament by law can empower any of the courts within local jurisdiction of India to issue writs, orders, or directions guaranteed under Article 32 clause 2. But till date, Parliament has not given this power of issuing writs to any other court except Supreme Court and High Court. Then 32 clause 4 states that rights given under Article 32 cannot be suspended except when such suspension is provided by the Constitution. That is when emergency is declared by President of India, then Article 32 can be suspended. This power to issue writs, dear students, is the original jurisdiction of the High Courts as well as Supreme Court. It is not appellate jurisdiction. Now we'll see the scope of Article 32. Scope of Article 32 is not wide enough as that of Article 226. Why? Because Article 32 can be invoked only to enforce fundamental rights under Part 3rd. One cannot approach the Supreme Court for enforcement of other rights except fundamental rights. And power to issue writs under Article 32 is mandatory for the Supreme Court because Article 32 is itself a fundamental right. And Supreme Court is the protector of these fundamental rights. The writs are strong instruments issued against the government and government officials. Now let us see the scope of 226. As I told you earlier, the scope of Article 226 is much wider than 32. Article 226 not only gives the power to issue directions, orders, or writs, not to enforce fundamental rights, but also for enforcement of other rights also. Article 226 empowers High Court to issue directions, orders, or writs to any person, authority, or government or public officials. And Article 226 also talks about the interim order for writs and also states the mechanism of how interim order will be disposed of by the High Courts. Article 226 clause 1 states that in spite of Article 32, High Court has the power to issue direction, order, or writs, including the writs in the nature of writs in the nature of habeas corpus, Mendemus, Prohibition, Quo Warranto, and Certiorary to any person, authority, or government or public officials for enforcement of fundamental rights or any other rights under its own local jurisdiction. Article 226 clause 2 states that in spite of the seat of the government or authority or residence of the person is not in the local jurisdiction of the High Court, still High Court can issue direction, order to such government, authority, or person if the cause of action wholly or in part arises in relation to its own jurisdiction, meaning thereby that address of the defendant, address of the respondent is not material. It is the cause of action which is material. If the cause of action has arisen in Noida, the Allahabad High Court will have jurisdiction. Even if the respondent is residing in Delhi, that makes no difference. And 226 clause 3 states that when against a party, any interim order is issued by the High Court by way of interim injunction, or stay order, or any proceedings relating to a petition under Article 226 without giving copy of the petition or copies of all documents of the interim order to such other party, and B, without giving any opportunity of hearing. That means the stay order is passed on the very first day or during the pendency of the petition. A stay order is passed and other party is not heard, and copies are not given to the other party. Now the other party against whom the stay order has been passed, if such a party makes an application to the High Court for the vacation of such interim order or petition, and also furnishes a copy of the application of the vacation to the party in whose favor such interim order or petition is made, or to the counsel of the opposite party, then what will happen? High Court shall dispose of this application for vacation of stay within a period of 2 weeks from the date on which it is received, or from the date on which the copy of such application is so furnished, whichever date is later. Or where the High Court is closed on the last day of that period of 14 days, 2 weeks, then before expiry of the next day afterwards on which the High Court is open. And if this application for vacation of stay is not disposed of by the High Court, the interim order or the stay order which was granted on the very first day shall, on the expiry of that period of 2 weeks, or as the case may be, on the expiry of said next day, will be vacated. That interim order shall be vacated by the High Court, shall be deemed to be vacated if that application for vacation of stay is not disposed of within 2 weeks. The reason is that the person who gets the stay order wants to continue with the stay order because he is getting benefit out of it, whereas the person against whom the stay order is passed, he wants that this stay should be vacated as early as possible. So the mechanism of law under Article 226 is that after grant of stay order, if it was granted without hearing the other party and without supply of copies, then the person against whom stay order is passed, he will apply for vacation of the stay. And he will supply copy of this application to the petitioner counsel or to the petitioner himself. And now within 14 days, within 2 weeks of supply of copies to the petitioner, this application for vacation of stay has to be decided by the High Court. And if it is not decided within 14 days, then the stay order granted shall be vacated automatically on the expiry of 2 weeks. Then 226 clause 4 states that the power given to the High Court to issue directions, order or writs will not derogate the power given to the Supreme Court under Article 32 clause 2. See, the jurisdiction of High Courts and Supreme Court is concurrent. Okay. Then what are the writs which can be issued under Article 32 and 226? The first writ is habeas corpus. Although we have covered this material in the previous lectures also, but for the sake of clarification, I am telling you once again the details of the writs under Article 32 and 226. So the first writ is habeas corpus. It means to produce the body of or have a body of. This writ is issued by the court to the person or authority who has detained or imprisoned any other person, to bring that person before the court so that court can examine the reason and validity of his detention. If no valid justification or reason for his detention is found by the court, then the court will release him from that detention. Writ of habeas corpus can be issued to both public and private persons. It can be filed by anybody on behalf of detainee. Second writ under these two articles is Mendemus. Mendemus literally means we command. In this court order, the public authorities directing them to perform their duty imposed by law. The writ of Mendemus can be issued to the government officials, public corporations, inferior courts, or tribunals, etc. It cannot be imposed on private persons. It is issued when public authority refuse to perform an obligation under law, but it cannot be issued where duty is discretionary. Third writ is quo warranto. It means what is your authority. This writ is issued by the court to the person holding the public office, questioning him under what authority he is holding the public office. If he fails to prove his authority, then the court will issue order refraining him to hold that office, and court may ask him to vacate the office also. This is quo warranto. Fourth writ is certiorary. The writ of certiorary means to be certified. This writ is issued to the inferior court or tribunals, directing them to transmit the matter to the court of record proceedings pending before them. This writ gives power to the Supreme Court or High Courts to determine the validity or legality of the matter disposed of by the lower courts or tribunals. And fifth writ is prohibition. The writ of prohibition is issued to the lower courts or tribunals when these conditions are fulfilled. Writ of prohibition is issued when, number one, the lower courts or tribunal, they act in contravention to the rules of natural justice. Secondly, they act without jurisdiction or excess of their jurisdiction. Third, they act ultra vires, that is beyond their powers given by the law. They're acting beyond the powers. And fourth, they act in contravention of fundamental rights. So writ of prohibition can be issued in these four circumstances. Then let us see, dear students, how Article 32 is different from 226. The first point is Article 32 gives power to the Supreme Court, whereas 226 gives power to the High Court. Second, Article 32 is invoked for the enforcement of fundamental rights, whereas 226 is invoked for enforcement of fundamental rights as well as other legal rights too. Third, the power of the High Court under Article 226 is wider than power of Supreme Court under Article 32. Fourth point, power to issue writs under Article 32 is mandatory for the Supreme Court, whereas the High Court has discretionary power to issue writs under Article 226. Fifth point, Article 32 is can be suspended during the period of emergency, whereas Article 226 cannot be suspended even during emergency. Sixth point, the territorial jurisdiction of the High Court under Article 226 is narrower than territorial jurisdiction of Supreme Court under Article 32. Why? Because High Courts are to exercise their jurisdiction within the territory of a state. So state is narrow than the jurisdiction of the Supreme Court, which extends to the entire country. So obviously, the territorial jurisdiction of a High Court under Article 226 will be narrow than the territorial jurisdiction of Supreme Court under Article 32. Seventh point, the order passed by the Supreme Court under Article 32 will always supersede the order passed by the High Courts under Article 226 because the Supreme Court is the highest authority in the hierarchy of courts in our country. Then point number 8, Article 32, dear students, is itself a fundamental right. It is a right to constitutional remedies. Whereas Article 226 is not a fundamental right. Then we'll see the similarities between Article 32 and 226. Similarities are: number one, both Article 32 and 226 are invoked for the enforcement of fundamental rights. Yes, this is common. Second, both the Supreme Court and High Court has the power to issue writs under Article 32 and 226 respectively. Same 5 kinds of writs can be issued by the Supreme Court as well as by the High Court. So this is the similarity. To conclude the matter, my dear students, I can say that Article 32 is a fundamental right which empowers the Supreme Court to issue direction, order, and writs. Article 226 is a constitutional right which empowers High Court to issue a direction, order, and writs for enforcement of fundamental rights and other legal rights also. And the writs in the form of habeas corpus, Mendemus, Quo Warranto, Prohibition, and Certiorary can be issued under Article 32 as well as 226. So it is concluded that the scope of Article 226 is wider than that of Article 32. And unlike 32, Article 226 cannot be suspended during the period of emergency. So this is, my dear students, in nutshell,